guests. We're really, really glad to have you all here. You always have that feeling, will anyone show up? So we're delighted that first thing in the morning we've got a few people here. I'm Leslie Hughes. I'm the founder and CEO of iSpy Technologies, but I'm also here really wearing my hat as president of the Digital Media Licensing Association. And I'm here with my friend and associate Nancy Wolff, who is a partner at Cowan Debates, Abrahams and Shepherd. After about 20 years, I finally learned that. And she is DMLA's legal advisor. So bear with me. We're going to start off this session this morning just talking a little bit, like everyone is, about generative AI and what's happening in the world today. So let's see. So the first thing I did is I went to ChatGPT and I said, write an opening for a presentation on generative AI in a professional voice. And it did in seconds, as you can see. And I won't take the time to read it, but it's not bad. It's kind of generic, but it's not bad. I then said, now write a joke that I can tell the audience. And the joke was, why does AI want to cross the road? And that was to get to the other side of an algorithm. I thought that was cute. So what we know today, generative AI is exploding. As we all know, we have text to text, text to image, and image to image. I'm going a little faster than the video. These are some things that shocked me. ChatGPT reached 100 million users in 2 months. In January, they had 569 million visits from 100 million unique users. Stable Diffusion, if you don't know it, do, because our clients, I'm gonna actually go back to that. If you don't know it, learn, because they are a downloadable app, so they don't really track the web users, but they have a valuation of over $1 billion today. And we deal quite a bit with people in the advertising world, and Stable Diffusion is their #1 tool. Midjourney in February had 56 million visitors from 25 million unique users. The kitties, by the way, were a Midjourney. All right, so this is a guy that I know that's in audio. He created this. There's nothing about this is live, including the voice.
Problem of not paying assistance enough. What makes it worse is the attitude behind it, which is we don't need to pay as much as everyone else because this is such a great opportunity.
So you can see, here's a guy that I follow on Instagram that is very into the fantasy. This is all generated, the music, everything. He uses Stable Diffusion, so you'll see from a couple of the samples that I've included here just how crazy and wild and sort of fantasy-like they can get. We'll show you a couple of these. This one I thought was interesting because it shows you how he can immediately change the face of the human, or the non-human, sorry, and he can immediately change the background. So this is with a click of a button. And I think I've got one more. All from scratch. Now this guy happens to be a graphic designer at a major New York ad agency who is very much a proponent of generative AI, and in fact they're using these tools for clients right now. In light of the second part of our conversation today is the copyright issues. This one stunned me. This is all generative AI. The sound, the stills, the motion, the music. You'll see at the end a generative AI person speaking. This is just the beginning, and the quality of this could be an expensive production.
The AI is one step ahead of us and seems to be targeting our supply transports, leaving the weapons and vehicles we need for the front lines stranded. It feels like the war is slipping away from us.
So Bria is one of DMLA's companies. They are very much trying to focus on ethical AI. This is their tool, so you can see how easy it is to change backgrounds. They are also promoting not needing prompt engineers, which if you all have seen the HR posts, they're hiring prompt engineers now. You can put in an Irish pub interior and change the background for an image. Click on it, select the one you like, and you're ready to go. I think that's pretty cool. And this I love. For years, agencies have had trouble taking a campaign from one country to another. And with Bria, you can literally change the face, change the ethnicity, change the background at the click of a button. Here are a couple of editorial shots that were posted, fully generated AI. They're not bad.
Is this editorial or advertising?
Well, they were listed as editorial, so I'm speaking. Visual is another company that's a DMLA member, very strong voice for ethical AI. They're generating data sets and generated humans, but all from content that is cleared and clean, if you will. All right. Yeah, please. Yeah. Nancy?
Well, figured out how to turn the microphone on at least. So good morning, thanks for coming early. About the year before last, I was saying NFTs are my life every day, question on NFT. And beginning of this year, every day is AI is my life, and getting lots and lots of questions, not only from creators worried about their content being used to create competing works, but also creative people who use AI and like, when is it appropriate to use it? When is it ethical to use it? What are the risks of using it? And so we'll get into a lot of those questions today. And like everything else, technology goes way faster than law. Every law association I'm with is having like emergency task force. I'm on the American Bar Association, ABA, IP task force on AI and machine learning. The Copyright Alliance is having a task force on AI. I know the Authors Guild is really, watching AI as they worry about having authors replaced by computers. And I think visual artists have that same fear that in seconds someone can recreate something that has taken you forever. I was at a National Geographic meeting, and they were doing a presentation on AI, and a photographer I know who does these day-to-night images where he'll be 30 hours in one spot and take an image that shows the entire landscape over a course of at least 24 hours, where he stitches together thousands of images, and it takes a really long time. So someone's selling one of his images where they had just changed it from day to night to all day. It was like in 1 second. So.
Nancy, if I could jump in, my daughter's a graphic designer and she loves to do illustrations. And illustrations can be done in seconds. Some of the work that you saw in there, the kitties, for example, it's scary to artists. They're trying to figure out how this tool is something they can use and how it fits in with what they're doing. Let me ask you a question, Nancy. So I'll start with a statement. So Digital Media Licensing Association is our organization, and we're supposed to be the voice of the industry. We have a legal committee that has some pretty strong companies on it, with Getty and Shutterstock and Adobe and Storyblocks and others. And everyone's at a little different place with their feeling about AI and using AI right now. And I'm curious, with where we are in terms of the law, do you see that getting reconciled in the next year?
Well, the next year may be a little bit too short. Everyone's approaching it from different perspectives. I think in terms of submitting content with the AI, I think at this point Getty Images is saying they're not accepting content with AI right now. I believe Adobe has policies on when to use it and when not to use it. For example, I think because of the issue of not copying another artist's style, they recommend not to do search prompts make me a Warhol, or make me a Picasso or something like that, which you can easily do, and to avoid trying to have images of recognizable people or places because they may not be authentic. There's so many issues involving AI. I look at it as like, what are the issues with the data sets, sort of the input? Like what was it trained on? Were they lawfully acquired, the training material? Will the law permit the scraping of images from the web? But then you look at the output. What if you make an output that looks just like someone else's work? Who's responsible? And we'll get to those questions, but these are a lot of the issues. But then you have issues of privacy. If sites like Stable Diffusion are now allowing anyone to license things for commercial purposes, if you have recognizable people that are made up, you could be using them for reasons where you won't have a model release, or when you're creating images, should there be some kind of disclaimer so someone knows that they're looking at something that's generated? We've had so many issues before the rapidly improved generative AI, just with fake news already, with traditional tools, just using Photoshop. Can you imagine the next election? I mean, it gets a little terrifying when you think of all the repercussions. The organization in Europe, CPIC, has been putting together some sort of AI recommended best practices that deal with things like transparency and when it's appropriate. But these things are all evolving, and there's no case to court decisions yet.
The thing that interests me about the graphic designers that are so excited in using this in their professional work for clients is there was a recent, decision by the Copyright Office to revoke a copyright that had been previously granted to an image. I think it was used for a book, because they said they did not know it was generative AI and it lacked the human creation required. So if I'm PepsiCo, this agency, I won't say the name of the agency, but they work for very large companies in the healthcare space. And if they're creating work using generative AI, I think there's a huge question if they can protect it and what impact it has on their brand. If they take something that was mostly generated, but it happens to have their brand, is that protectable?
Well, right now, the U.S. Copyright Office says that anything that isn't created by a human author is not protectable by copyright. There's a lawsuit going on where that's being contested. It's Thaler versus Perlmutter. Right now, Shira Perlmutter's the Register of Copyright, so she gets to have her name on the lawsuit. But there's been more than one. There's been the one where it was just Thaler's, where it was just images that were created with AI and weren't allowed. And then recently there was like an illustrated graphic novel where they allowed the text to be protected, but not the illustrations once they learned they were from AI. So if you're creating something for a client and you just put in search terms and you come out with an illustrated product, that illustration, if nothing is altered or changed about it, will not have copyright protection. If you maybe then use it either just for inspiration and then create something original on your own, then the work you created where you just use that one for inspiration would be corrected by copyright. Or if you generate something and then you manipulate it and add it, if you've added what the Copyright Office would consider something original, it could be derivative of the underlying public domain work. But right now that works in the public domain, which means anyone could take it. So when you generally do work for an ad agency, they often want either exclusive rights or they want work for hire because they want to make sure that that image is always associated with their brand. So if you're working for a creative agency, you can't give the representations and warranties to the brand. So when I've been advising some design companies, I've been warning them that that maybe using generative AI is great for ideation and coming up with ideas, but you don't want it to be the only thing in your final product because you won't be able to give anyone exclusivity.
Yeah, and clients are today. I mean, I think the interesting thing Nancy mentioned, Shira Perlmutter, she was at a conference of ours last October, and she told some history about the fact that there was real resistance to copyrighting photographs because they were taken with a machine. And so you think about that, it makes me wonder if that is going to evolve in this space and what in fact will become the human creation that may allow this content to be copyrighted. I don't know. So Nancy, I have a question for you. So Getty, I think most people that are around digital media know that Getty has sued Stable Diffusion. Can you talk a little bit about that? I understand they're alleging that they're copying and pre-processing images protected by copyright. So this is the two sides of the coin, right? There's the copyrighted work that is photographs, video that is copyrighted, and then there's the creation of the new. So let's talk a little bit about Getty's lawsuit with Stability and kind of what they're alleging.
Well, the only way you can create you can have generative AI is if machines are trained to understand that if you type in the word cat, what a cat looks like. So they need lots and lots of images of cats, or they're not going to know what's associated with that word. So most of these generative AI have training sets that are primarily created by scraping thousands to millions of images on the web. And you can find out if your images have been trained. There is a website called Have I Been Trained? And it's obvious that most of the major stock agencies, even smaller ones, have had their content scraped, whether it's Alamy or Shutterstock or Getty or Adobe or Josephine's agency. I mean, your images are in there, and they've been trained to make images that are essentially going to compete with your images. And I think that's probably part of the galling part of it, is that you've assisted the competition, and so I guess one, you could try to negotiate and get licenses for that, but right now it seems that that's not what most of these training sets. Some of them are open source, and I think they really have not had a practice of licensing. So
let me jump in. I want to key off something you said. It's competition. If you have used these tools, you know how easy and quick it is. So it's actually competition and a new kind of search. You know, we have a company that does some marketing intelligence surveys every year of this industry. And 8 years ago, they said it took them 4.5 hours to find an image for a project. 2 years ago, they said it took them over 8 hours to find an image for a project. That's why they love this, because they can go in and put in exactly what they want, and they find it like that. That's scary.
yeah, so maybe I'll turn around and show you a picture, then I'll tell you what some of the claims are in the Getty case. This is an example, and that's in the Getty complaint, where you can see that this is the original image, and this is generative, and the watermark is still in it. So it seems like in the training data sets, sometimes there's not that many images that they're trained from, and you can readily recognize the source. So I think a lot of times when people think about the data sets that are made for training, that it's like, oh, we use 100,000 different pictures of a cat, so you'll never recognize your cat picture. But maybe for certain subjects that there aren't as many options. So if you look for certain soccer players playing together, you're going to end up with something that's very derivative of an original work. And the fact that even the watermark is still on it sort of speaks volumes, as they say. But anyway, so what Getty brought they first wrote a letter to Stable Diffusion in the UK, because under the UK law, I think you need to give someone like notice before you bring a claim. I don't think anything's been filed there yet, but they filed a claim in federal court in Delaware against Stable Diffusion, and the claim is based on copyright infringement of images, and I think because Getty has a large editorial library, it actually owns a lot of its own images, because in order to bring a copyright case in the US, you have to have a copyright registration. They also registered the text that's in a lot of the caption and description and metadata, because a lot of the editorial images have a lot of details that make the images useful, and a lot of information about the context of the images. So there's a picture of this is a drought in California. So the text will say, a section of Lake Orville is seen nearly dry on August 19th, 2014 in Orville, California. As the severe drought in California continues for a third straight year, water levels in the state lakes and reservoirs is reaching historic lows. Lake Orville is currently at 32% of the total 3,537,577 acre feet. And then it says photo by Justin Sullivan / Getty Images. Well, that text is likely sufficient enough and have enough originality under copyright law that would be protectable in itself. So these are some of the things that are also being scraped, because the images without the text, so the machines that are learning know that the cat is a cat, they have to take the text with it too. So Getty Images registered the images, it registered a database registration for captions and text, and it also brought claims for infringement of copyright of both, and then under the Copyright Act, there's claims you can make for altering or removing copyright management information with the intent to facilitate infringements, and that's under Section 1202 of the Copyright Act. So they brought claims for the alteration of their watermark. As you can see, it was sort of distorted watermark on these images. And they also brought some trademark claims and some unfair competition claims, because by using the Getty Images watermark, you're using a trademark. The focus of the case is, a lot of it has to do with the competition part, because it's very likely that the argument that the companies like Stable Diffusion will use is that the scraping of the internet is exempt from copyright because it'll fall under the doctrine of fair use under Section 107.
It's interesting because there's so many issues around this. I don't think it was in the opening. I think I decided to shorten it, but I found this amazing generated art that was to illustrate news headlines. So I don't know if that was in there, but basically what he did is he took the headlines, for the earthquake, for example, and then put a headline. The headline may or may not be right. It was his sort of modified, I'm creating this art to illustrate news. That was his approach. And it was interesting because those images weren't real. Is that an editorial problem? I don't know. So there's this issue of scraping the images. Are you taking content that's copyrighted? There's the issue of deep fakes. Our friend and associate Andy Parsons is going to be on a panel, I think on Saturday, maybe Sunday, about deep fakes. And he runs the Content Authenticity Initiative. And the Content Authenticity Initiative is actually trying to think through the way that they can help by tracking provenance even on these systems. And he and I had a conversation what they were looking at, I'm not saying anything of what they're doing, but we had this conversation that you could envision them going to OpenAI and starting to track the versions of OpenAI, where the images came from, where they scraped, and as this law evolves, be able to still track and know the original source, even if it was scraping, which I think is interesting. So you run the gamut of protecting copyrighted works now, all the way to these ad agencies that are creating content for brands that really isn't protectable right now. So,
Right, yeah.
so I think one of my questions is if you were defending, if you were working with Getty directly on this case, what would your projection be of the outcome? Is this something that it's going to be complicated, take a long time? Do they have a good shot? Do you have any sense?
Well, what will happen is, of course, there'll be, usually when a case is filed, everyone wants to find a legal reason to have it dismissed right away. So I predict that Stable Diffusion will try to immediately have it dismissed, trying to say that the act of scraping is a fair use under US copyright law because it's transformative. There's no case just like it. Fair use is something that gets decided factually on a case-by-case basis. The only thing similar from the past could be Google Images or the Google Book case. So when you do fair use, you have to look at 4 factors. The first one is the nature and character of the use. They will claim that this new technology, just like search in the days of using images from search, is so transformative that it doesn't replace the underneath images because they're creating all new ones. The second factor is the nature of the work. Are they creative works or factual works? I mean, they're all photos, so they'll all be in some ways creative. The third factor is how much did you take of the original? Well, they're ingesting full images. They then, what they do is they create noise, sort of take the images apart, and then apparently, as I understand it, then the machine learning is then trained to sort of put images back together without the noise. That's sort of a simple.
And to generate new images.
To
which I
generate
think
new
is the
images.
combination.
So, but at one time they have to have the full image as well as the text. The issue may be how long they keep it. The fourth factor is going to be the really interesting one, because that's the market harm. And you don't just look at market harm now, but market harm if this use became widespread. And I think that's where there's going to be a lot of issues, because if you're just doing this for ideation or fun, or kids just want to make cats with wings that fly all over, but they're allowing, and they will be, and they're having subscription models, so you can use these generative AI images for commercial use. And now you're taking content that was, developed, marketed, curated for commercial use, being used to train machines so you can create competing images with no effort. And I think that's where there's going to be a lot of issues, and probably experts will come in. Whatever the lower court decides will, of course, be appealed and go up to a circuit court, and that takes time. And I can't imagine, it's something that could easily go up to the Supreme Court.
So let me raise, I was just going to say, let me say one comment and then let's open it up to questions. The one comment I wanted to make is I read something really interesting about generative AI learning one's style. So think Picasso. And this particular article was about a portrait artist, a painter. And every image that she's ever uploaded of her paintings of portraits was scraped and pulled in. And the generative AI was not only generating new content, but learned her style. So the new images were being generated in a way that previously had been unique to her. I don't know if you've got a comment on that, and then Joe will come to you.
Yeah, this is a real issue for illustrators who often have a lot more style than you could even see with photographers. Some photographers definitely have a unique style, but particular illustrators, there was another article in the New York Times a month or so ago, how this one illustrator had all her work scraped, and then these alt-right groups were using her style to create illustrations and political illustrations with comments that were completely contrary to her beliefs. And it's really difficult because copyright doesn't protect style. You actually need to find substantial similarity between two works. And
But copyright protects use with sensitive subjects, I believe, still, right?
You're mixing up
Well,
right,
no, what I
privacy
was-
and copyright. Copyright protects unlawful reproduction of works, and to have an unlawful reproduction, you have to have access, which they do have.
Right.
But there has to be substantial similarity of copyrightable elements. So if the only thing taken is style, there's cases that don't protect style, so it's going to be interesting what, and I think that's why things like trademark law are coming in.
Well, let me ask you a question. So this is a real life example. I haven't tested this with Nancy yet, but so if a work is copyrighted in photography and then coming out of the licensing industry many, many years ago, I don't know if it's still true, but for example, we had a lawsuit in a company I was in where we had licensed an image of a man laying in a bed, perfectly appropriate image, man laying in a bed that was used for the cover of a magazine with the headline about AIDS. And so that had not been cleared for a sensitive subject use. So my point was, if this is if it becomes copyrighted, it's not today, but if they're generating, and it's this woman's style, can they then generate a new image and use it for all right? Or in theory, if it was copyrighted, would she have that same right to ensure that they came back for additional releases?
So we're in some ways mixing apples and oranges.
Which I like to do.
Right. So the picture, going back to the person in the bed, what the sensitive release was the context of how the image was used and the fact that there was AIDS related, and I've had several cases like that. That only deals with the model and not the owner of the copyright of the image. So if you used a picture, and this is where the visuals images are relevant because they're creating synthetic images where they have taken pictures of with models that have signed very broad releases that would permit sensitive uses. So in the case with someone, but this is the risk of ad agencies and others using generative images, because you may not realize that the what you think is a synthetic image really looks like a person, and you could use it in an ad about some kind of pharmaceuticals or a disease or a drug or an article that could offend someone, and you won't even know it because there'll be no releases with those images.
But fair enough, actually it could be, in the flip side, a good tool for organizations that are dealing with politics or something that might be deemed sensitive to create new imagery if it is new.
But I think it'd be much safer if you did go to a company that created them that had releases.
Yeah. Joe?
Yeah, so I was just curious. What is Getty actually hoping to accomplish with the lawsuit? Because the cat's already out of the bag. They've already trained, the model's been trained on their images. Are they just trying to shut it down? Or what are they trying to do?
Under copyright, you can get injunctions, you can have monetary damage, you can get statutory damage, and you can have destruction. So I'm not the attorney on this case. They possibly, I mean, right, once something's been trained, you can't untrain it. So I don't know what the end game is, trying to stop it or trying to control it, or maybe have their images removed from future training. I don't know. I mean, the copyright law has, you know, a bag of remedies, but injunction is one of them. I mean, anything already created, you couldn't do anything about, but maybe forcing the industry to try to get legitimate licenses and only using images for training that are released properly. I don't know.
Hi, I'm Alex Demakis. I have first a comment and then leading to a question. So, Stability didn't actually train Stable Diffusion model. Stability actually donated money to a university, a German university, which trained, and also the German university didn't scrape the data. The data is scraped by yet another entity called the Common Crawl,
Right.
which doesn't even host the data. It actually literally just crawls the web and makes a big text file that says, here's an image, here's the link to the image, here's an image, here's the link to the image. And the person who's hosting the image can just decide to take it down any day or change it or do whatever they want to the image. So nobody here, so I just want to, my comment is really, nobody gets scraped because basically people upload their images to the internet, and then robots like Google are just indexing, making big lists saying, oh, you uploaded your image on DeviantArt, on Reddit, here's the link to that image, I'm just keeping that. If you want to take it down from Reddit, then you know, talk to Reddit. Now,
But they are converting images to text, so that it may be looked at as whether it's true or not. I know there are the layers. I know it went through the university,
They are
and
not,
it
they're
wasn't.
not, yeah. They're not. So since we work on exactly this
Yeah.
topic, and I'm leading to my question.
Yeah.
The only text they store with the image is the alt text of the URL that is there in the original website.
So
yeah.
the Copyright Act talks about how you can you can violate a display right by using technology means. So it's going to have to be interpreted as whether sending someone to that URL is authorizing some kind of reproduction or derivative. They'll have to go through that process.
Right.
But in the end, if you see the end result, there had to be some transferring of visual data for the end result to come out with something that looks so close to that soccer player.
Absolutely, but the person who actually went to the URL, let's say you're an artist, you create your own website, you say, here's my art. You host it on your own website.
Right.
I publish a list that says, this is a great artist, this is a link to their image. I'm not storing your image. Okay, now, the university, so that's Common Crawl. Common Crawl gives this list to Maximilian Ludwig University in Germany, which trains Stable Diffusion. And Stability, Midjourney, and Runway are three companies that are using this open university-developed model. So my question, since I have to have a question, is who? Like, I know they're suing Stability, and I don't know if I'm not a legal expert. I'm an engineer. I don't know the legal implication that Ahmad on Twitter clarified very clearly that we didn't train Stable Diffusion.
Right. So under copyright, you can also be liable for contributory infringement if you facilitate the infringement. And what it is, none of these universities, because I've dealt with some of them that are dealing with it, they all get funded to create these things that then can be used commercially. So there could be a claim for not direct copyright infringement, but indirect through the contributory infringement. And
Nancy, it's an interesting point though. Back in the day, I worked for a smaller company that was owned by a bigger company that was owned by a very wealthy person. And when we got sued, everybody got sued. The smaller company, Kodak was one of the owners, Bill Gates was another, and it didn't matter. And it was because of a similar, again, very different, but it was a similar thing. It was like, who is at fault? And while I'm not aware of a suit now related to Stable Diffusion that has taken it as far as you're raising it, but I'll tell you, if I were the one with lots of money and we're going to sue them, I'd sue everybody. If only to get the question answered of what is legitimate. But we have members, very small young company in the South is creating data sets and is licensing them for training. And this is going to kill their business if you're just allowed to go online and take it. So I think these are all the open questions. None of us know where it's going to end up. But I suspect it's going to be lawyers' heyday for the next few years.
And people who understand the technology like you who try to look at whether there's really any copying anywhere, and the courts will have to look at whether under the act, these acts of linking back and giving code information about content, how that relates to the definitions that we have in the Copyright Act.
It's funny, one of the creators that I showed some of their work that he's in the agency, he was like, this can be end of stock photography or stock licensing and all of this, and he said, and I think it's great. And I said, okay, you're an artist, right? And he said, yeah. And I said, so you create something, you want to be able just to let it be used for anything without your input on whether or not and how it can be used. And it's funny because he said, well, so do you think they'll shut down these tools? I don't. I mean, again, conjecture. But I think these tools are going to change everything. I really believe that.
Yeah.
But I do think there's going to be this period of getting past the hype and figuring out how to use them in an ethical way. So, yep.
I don't need the mic, people can hear me.
No, we'll give you a mic.
So, a number of years ago, before we were called the MLA, I forget what we were called before the MLA.
Picture
HACA, sorry.
HACA.
And we were in a basement in New York, one of our annual shows, and one of the things that we were talking about, I think Nancy we were talking about presenting, was a famous photograph that some artist stole, basically 95% of it, and changed it a little bit, and there was a lawsuit, and the artist won. Do you remember what that was by any chance?
There's been many though. Where they
So I'm just
Was
curious.
that
about
the Jeff Koons case?
It could have been.
The
And-
where they took a photo and made it into a sculpture?
No, it was one where they
Okay.
turned it into just another print, and they sold prints all over the world and made lots of money. And there's a lawsuit because they basically stole that image, and the law and went to court, and the law said that it was changed just slightly enough that it was okay.
so
and they got
Richard
away with it. I wish I
Prince.
can remember which.
Was it Prince?
Yeah, it's Richard Prince.
Prince, it was the
But
Carol
Haitian
Prince.
photo.
Was that the one?
It
Carol?
could have been that one.
Because that one, there were some that were changed enough, they were collage-like, and some where they just added a little bit on and they weren't. So like 25 out of the 30 images were fair use and 5 weren't.
So it all came down to fair use, is what it
Yeah,
was.
it's all fair use.
So I remember the ones that got away with it. I mean, it looked exactly like the photograph. Hardly anything changed, and they got away with it. So my question is, what's the difference between this and that?
That will be the
That's the
question.
I
Has it
don't
been
see a
changed?
difference at all. I don't.
No, it's the same question. It's the transformative use question. Is the end product so changed? But I think there's going to be questions that relate to how the training sets are made, and then questions about the end product that comes out and who's responsible. Is it like who is responsible if you put in words that ends up looking just like someone else's artwork by mistake? Is it the company that has the platform? And then also, if you're creating a work for a client and you type in a few words and you come out with a resulting image, who owns that? I mean, are the platforms going to try to claim they own it and you get a license from that?
I think so I'm gonna make a prediction, which is always dangerous. I really believe the one bit of consensus that I'm hearing from talking to a lot of different organizations is that work that's copyright protected, the holder, the owner, should have the right to say how it's used. So my prediction is at some point we're going to evolve, but I can also see a Wikipedia for training data being created, a free source where you can go train on, as well as companies that'll provide this. I don't know what'll happen, but I don't think it's gonna go away. I think the one consensus point that our members in the Digital Media Licensing Association come to is that, again, copyrighted work should be allowed, you should be allowed to say how it's used. That's it.
Right.
From that point forward, it's, open.
And the interesting thing is that, fair use is a very US doctrine, and in Europe they have fair dealing, which is much more limited, and a lot of countries just have statutory exceptions. And it may develop that there's compulsory licensing. I mean, there's a lot of avenues this can go, because images now are worldwide and it's just not US. So we're just at it's here and it's happening fast, and law, as I said, happens slowly, and we're at the tip of the iceberg. So it's hard to predict what will happen at the end, whether there ends up some kind of compulsory licensing scheme, whether there ends up being a lot of cases that I know there have been, there's some very strict laws in the privacy area about using biometrics, and companies are being sued about that. And so I think there are going to be uses where companies aren't going to want the risk of these open source AI where you don't know where they came from, and that they will feel safer using a more curated set where they can rely on releases and they won't have liability in areas of privacy. Europe also has a lot of regulations on revealing private information about people, and certain states in the US have some too, like California and others are joining. So you have to think about not just copyright, but privacy rights and a lot of other things when you look at this.
Shifting gears a little bit, Nancy's firm specializes in digital media and entertainment and these areas, and entertainment is an interesting question to me. We have a guy who's going to speak this afternoon from Jimmy Kimmel Live, and his career for a long time has been rights and clearances, and he's now getting into the producing, and he has a film premiering, so it's going to be interesting. You know, my question is, movie companies spend millions on CGI, right? And this is really going to impact that because CGI has now just gotten a lot easier. But my question is, if you use generative art in a movie feature, does that impact the copyrightability of the entertainment, or how does this translate over to the entertainment space when they're, you know, companies that are members of DMLA license content for the movies all the time. So I'm curious how this goes over to that.
Right, well, the little elements and the clips that make it licensed from a DMLA member that get incorporated into a movie, that's just one of many, many elements in the movie. And the movie as a whole will still be protected by copyright because that's, you know, going, you know, from beginning to end. There's still a lot of elements. I know that the Screen Actors Guild has been very concerned about generative video and the ability to recreate an actor. And New York recently sort of passed sort of the first deepfakes law, which was really pushed from SAG because they don't want their actors to be replaced by essentially an avatar. So that's a lot of what they're worried about. But if you have some background in screens, I mean, there's a lot of AI in movies now just in creating. It's not generative AI, but I mean, we've been using a lot of creative tools that have lots of AI in it.
Yeah, and CGI, I mean,
CGI is a lot of AI, and a lot of animation is used by creating AI, but it's really the generative AI, like the text to image where you can, you know, type in, you know, elephant in a watering hole or something, and you'll get it, and you won't have to send someone to Africa. I mean, there may be mistakes in it, it may not be authentic, and so some of the issues are, I mean, it's not a legal issue, but should it be sort of a best practice that you let the viewer know where something's real or not, and that's, I think, where that, the issue of content authentication that Adobe's been working on. A lot of the newspapers are joining them, New York Times and things like that, because you want people to respect the integrity of the news when they see it. You want them to believe that it's something that really happened. And so if you can review the provenance of an image, and you can see if anything's been changed.
I think it's interesting, the realness or the accuracy is, you know, I mentioned the artist who is creating images to go with certain headlines. But I was telling the story to someone last night, Leslie Stahl, the journalist, I think did a story on generative AI, and at some point she was talking to someone, I think from Microsoft and Bing, and they asked the system a question, and it came back and it said that, and forgive me, I don't remember the percentages, but 20%, 30%, whatever it was, of icebergs are created from penguins' urine. And so they went and they continued the conversation, and then a few minutes later, Leslie Stahl comes back and said, one of our researchers checked that, and penguins don't urinate. And so it was just totally wrong. And so she was saying, so how does the system like this, now this was text generation, but how does the system get it so wrong? And I'm sure you all have seen the articles, there's massive numbers of mathematicians that are saying the math is wrong. All of this will evolve, I think, and I think it will get better. But right now, there's no way to know. You know, it sounded reasonable to me, and when they came back and said, no, it's actually completely false, it is sort of a shocking thing. So I think, you know, that, I don't know, in today's world, and I'd be curious your thoughts on this, truth in advertising or truth in media and so forth is certainly a question. I don't think this is going to help it at least right now. Do we have any other questions? We've got sort of a few minutes left.
I've got one more.
Yeah.
So going back to what you guys were talking about earlier with, brands working with designers and agencies to create campaigns and using these tools to generate the visual assets, there is the issue where they kind of contract for this work, they generate it, but there's no human authorship, so there's no copyrightability. But if the AI-generated work has enough of the brand representation that it's clearly identifiable as Coca-Cola or whoever, could you not still be protected under trademark rather than just copyright?
Well, I'll let Nancy give you the legal answer, but I will say that I think this is going to evolve, and the decision, the DMLA and Nancy, I'm sure for a long time, has had a relationship with the Copyright Office, and I spoke with one of the associates to the register, Rob Kasunik, who was at our conference, and he was talking about the evolutionary nature of this, and they're not even sure where that line is going to be for human creation, but for now, it doesn't appear to be copyrightable, right? So I think, Nancy, you probably want to take this, but I think trademark would be the way to go after someone if your trademark is, that's what Getty's doing effectively, right?
Yes, Getty brought in the Lanham Act claims, which were trademark, state and federal. A lot of it because their watermarks are on it. Now, generally, trademarks don't apply to people, very few places. Some buildings have tried to protect elements of their building as a source identifier, because trademarks are different than copyright. Any kind of reproduction is not a trademark use. It has to be used as in a trademark way where it's a source identifier. But there are certain shapes of products that are so well known that they have something called trade dress. So that would be like the Coke bottle. It's, the certain designs of, some cars, like the old Beetle Volkswagen. There's certain things that are so recognizable by their shape. You have the Tiffany blue box, that they have trade dress protection.
I think the real answer at some point is that we're just going to have to see. It's going to have to be tested, whether it's Getty or other companies. They're going to have to take it to court to figure out where the boundaries are. I don't know if you agree, but.
Yeah, and until then, it'll be, it'll be just the Wild West. People will be using it, and there'll be problems, and I think that's why I'm getting a lot of questions. Not really what's the legal way, but what's what is the right way? If you have a creative design studio, the people that work with you are going to have completely different feelings about AI. Some will love it as a new tool, and some will be horrified by it. And so, what are the best practices? And some of it is, we'll use it for comping and ideas, but don't have it be the end product, because when your client can't even protect it. And try to stay away from areas where you could be really hurting other artists' rights, like making something in the style of someone else, or trying to make an image of a recognizable person that's fake. You just, because you'll get backlash from that if you do it. You push the edges too much from that. So.
Nancy, do you have any last comments? And I'll ask for last questions. Any other questions? Yeah, Josiane?
What's your name? I'm Alex.
Josiane, here, take this so we get the.
I will be up.
Oh, yeah. How many images you need, for example, of a cat to train it?
Yeah. The current models are trained in the orders of tens of thousands.
Tens of thousands?
Yes.
Because I'm like, you can license. Some of the companies actually have packages for trainers to get the images and train them like the right way. So I guess it's about talking about it so that they understand that there are tools, there are people who actually provide packages of training sets. And then once they do it right, I think everybody would be happy. Because you're getting paid for it, and you have your model released, approved, and everything is clean, and at the end it makes everyone happy. I think for us, it's just like you mentioned it, the lady whose her painting has been stolen. She said that she really felt violated. It's the same thing for us. Like, we pay for a lot of the content. We pay for production. We pay, we rent studios. We rent a lot of that to create that content. So it comes at a cost. So when we hear that some companies, some people just come to the website, and I know you say that it's automated, but regardless, we really feel violated. And we wish we had that discussion, because when it starts with a simple discussion. I think it makes things easier. We get it, we understand where we want to go, and we can provide a solution. So I think that's where it should go. We should keep talking about it so that everybody understands each other, understand the technology and how amazing it is. But I think there's also a business. There are many, many companies whose business is to create images for certain end users, and we just need to understand that there's a cost to it, and and we can provide content to everybody.
Here. We have 3 companies at least that are members of DMLA who do provide data sets for training.
I think a lot of them may that don't even say, yeah.
Yeah, I mean, Visual is probably, we have a guy who's on our board, Mark Milstein, who is very vocal about ethical AI. In fact, he was the first one I heard actually use that term months ago. And their business is built on creating all synthetic human beings and making them available for training. So, and then Bria does a bit of it, and then we've got...
But all the big companies, they've been licensing, I know.
For training?
There's been licensing of data sets going on with all the companies, I think, even if it's for a subset of data. But I even resolved a case for a European member who had a U.S. research institute just go to the website and just take their images, and it was used in articles. But the worst thing they did is they made a link and sort of gave a link in the research articles so that anyone could have all the images. And
which is what Alex, a little bit.
And so we got them to take that down, and it did get compensation for the company. And we went back and forth arguing fair use, but I knew at the time that there is a licensing for these things. So that was sort of the 4th factor, which hopefully stands up the most. But this case, it wasn't links. They broke into the back door and took the images.
That's gotta be illegal, doesn't it? Maybe that's a good note to end. Note to self, turn off your screensaver when you're doing a presentation. Sorry about that. So any other questions? We're coming to the end. Yeah, here. I'd like to get the sound on the little video we're doing.
So you mentioned the legal analysis for copyright is access and similarity. Is there a similar analysis for privacy rights? And I'm thinking specifically if, for example, an advertiser uses thousands of images to generate a person, a make-believe person, who looks somewhat like Kim Kardashian or somewhat like, vaguely resembling somebody famous. What's the analysis? And also, is there a defense that we didn't intend for this person to look like, fill in the blank celebrity? It just happened. It wasn't an intention.
Those are good questions. So copyright is federal law, so you sort of have one set of rules. In the US, privacy is state by state. Some states just have common law, some have statutory. And generally the line for right of privacy and publicity is that it typically has to be promoting some kind of commercial advertising or merchandise, because anything that's expressive or newsworthy is protected by the First Amendment, which is why all the editorial images we have don't need releases. But it just has the person, there's different tests in different states, so California is readily recognizable, but if something's even too similar, like Californians have sound-alike cases where advertisers have made music that sounds a lot like Tom Waits, and he never would ever let his music be licensed for any commercials. And there's an old case with Frito-Lay, and they purposely made a song that sounded like Tom Waits, and he was successful. So I think if you get too close, whether you mean it or not, if someone recognizes that person as a real person, there could likely be a claim. And with law, you can always file a claim, and then you have a lawsuit. So then you figure it out.
Nancy, one question, this might be too late to ask this, but one question. So if a person is in the United States and their work has been created, and they want to take issue against a European country, and Europe tends to have very strict privacy laws, is that doable? Could they, even if the issues aren't decided here, could they, if their face
Well, if the
or
content
likeness-
is used in another country, you would rely on the laws of that country.
Yeah, so you could take an action
Yeah.
in France or something. Okay.
Right, if you were
Yeah.
depicted, it'd have to be used there.
Yeah.
So that's how copyright law works too, because copyright, every country has their own copyright law, but we have treaties. So if
Yeah.
you have works and they're infringed in Germany, you can bring a case in Germany, Germany will apply German law. The area where you apply the law of of creation is ownership issues.
Well, and it's interesting because not only is the U.S. grappling with this, but every country is. And, you know, we're watching what's happening in the U.K. and in other countries because I think it will, you know, at some point they've got to, whether it's additional treaties or whatnot.
And some countries want to encourage AI. So Israel has had one decision that's come out that said that it is fair use to scrape for AI because they want to encourage development there.
Any other questions? Thank you all for coming. This is, as I said.
Thank you for being an audience. We didn't just have to talk to each other.